of the House Judiciary Committee. This is the November the 8th. We're going to have two briefings today, one on an issue related to fines and fees, and the second is going to be issues related to juvenile justice. Just for a moment, for a personal privilege, I want to thank all the members of the committee for all for what everybody has done and said. My family greatly appreciates the love that every member of this committee has shown us through a very difficult time. And so I wanted to just take even a moment to say thank you to all of you. Thank you to some of the people who are watching. You know who you are, who have been so kind in your comments and your thoughts about the passing of my father. So thank you all very, very much. And so now, with the most severe case of whiplash probably ever, let's talk about fines and fees. Let's do that. And we'll bring up Judge Morrissey, who is here, and Catherine Hager, the clerk of the Circuit Court for Queen Anne's County, who is here. I should mention for the committee and for those watching at home that this is have a new chief of staff, is Hunter Marsh. And this is his very first hearing, so we're going to see how he does. And I don't know why people are applauding him yet. I don't think he's quite risen to that level yet, but we'll find out. And now, see, the microphones aren't working right away, and all of the and that's because we're asking Hunter to be in two places at once. So we'll just take a second on getting the microphones started, and then we'll hear from the chief judge. This briefing, we'll hear from the chief judge, then from Maryland Legal Aid, and then from Baltimoreans United Leadership Development on the issue. We're going to try to be done with this by 2 so that we can start the next briefing at 2. And if all of you are really good and we're done before 2, that means you get a little break before 2 o'clock. So keep that in mind. Judge Morrissey, she can. Okay, that's fine.
I see.
Judge Morrissey, go ahead.
Good afternoon, Chair, Vice Chair, members of the committee. Thank you for inviting us to present this afternoon. As you mentioned, to my left, I have Catherine Hager, who's the elected clerk of court from Queen Anne's County. We're kind of dividing up the labor. I'll talk about the district court, and Catherine will talk about the circuit court. I do want to go on record, Mr. Chairman, as noting that I'm not opposing anything today. Nor supporting. We're just here for information. I hope that we'll be able to answer any. I'm 100% so far this session. Fines, costs, and fees, 3 broad categories, and I'll try to explain what each one of those are. Fines are statutorily created. There is some discretion that we have within a particular criminal event can have a specific fine, or it can be covered by kind of a general fine. And there is some discretion that I have as chief judge of the district court to set a prepayable for traffic offenses. And I'll get into a little bit more about that with respect to fines. And a fine, just so you know, would be if I'm in court and I say, I fine you $100. Typically, I would say I fine you $100 plus court costs plus CICF. That would be the fining of the court, and that would be $157.50. And I'll explain what each one of those means in just a moment. The costs, as I just mentioned, when I say the word cost, those are set by statute on the circuit court side and district court side. They're all set in the Courts and Judicial Proceedings article in the 7 series, 2 for the circuit, and 2 the 7.2s and 7.4s for the circuit, and 7.3s for the district court, and kind of outlines what those costs are. Costs can be waived if a defendant is found indigent, and I'll get to that in a little bit more detail at a later slide. And then finally, there are fees, and this is more of a circuit court thing than a district court thing, so I'll defer to Ms. Hager on that. So going into fines, the maximum amount typically of a fine is defined by statute in every case. For an example, a fine of an assault in the 2nd degree would carry a $2,500 fine, where a DUI or DWI would carry a $500 fine for first-time offense. All of the fines are dispersed to the general fund, save one exception. There is a surcharge on traffic offenses. Traffic offenses can be of 2 flavors, and it's kind of important to note this because it comes in a little differently later on. They can either be what we call payable or routine traffic, or it can be jailable or serious traffic is what we call it. And obviously you can go to jail on the jailable traffic offenses. On any traffic offense, whether it's payable or jailable, under Courts and Judicial Proceedings 7301, we have to impose a $7.50 surcharge, and that's on the fine. That's deducted from the fine. So if it was $100 fine, the first $7.50 goes to what we call VCAF. And what VCAF is the following. It's the Charles Riley Firefighter and Ambulance Rescue Squad Member Scholarship, the Maryland State Firemen's Association for Widows and Orphans, the Maryland State Firemen's, and then the Emergency Medical System Operations Fund. And each one has a certain amount that you all have put in statute that the monies go to from that $7.50. So remember, there is prepayment of payable traffic tickets. And again, this comes in a little bit later on in showing you the revenues and the disbursements. People are entitled to prepay prior to coming to court. And I have, Hunter, if you can pass out that book, I have the fine book that we publish every year. In fact, I just published it as of October 1st. We kind of wait for you all to get done with your session, and then I make changes to that book every year. And it just outlines the prepayable numbers that we've set. The typical fine for a traffic case that's not otherwise identified in statute is $500, but we encourage people to prepay by setting a amount that is in line with what other kind of comparable offenses would carry the charge for. So we try to keep everybody, and every time you make a change, I consult with either DNR or the MVA, and I have a whole talented staff behind me that will set up the parameters between what the prepay should be, and then I got to kind of select which one I think is appropriate. Costs on those regular costs, and so there's two different types of costs, but regular costs are $22.50. There is an additional $3 that are kind of a third layer of additional costs that would be on there in traffic only cases. So if you see my example in there, if there's a $100 prepayable amount, $25.50 are the regular costs and additional costs. So, and then there's the $7.50 VCAF that comes out of the fine also. So other than the VCAF, all of that money goes to the general fund. So 100 less $7.50 goes to the general fund.
So with the circuit court fines, an example of a fine could be assault in second degree or unlawful possession of handgun. That's all set by statute. So with the breakdown of the fines in the circuit court, 50% of it goes to the county law library pursuant to Courts and Judicial 7507, and 45% gets dispersed to the county where the court is located. And then the balance of the 5% goes to the state general fund for the circuit court fines.
So that's the fines. Now we're moving on to the costs. We've kind of mentioned them a few times before, but in criminal cases, court costs are $22.50 for the district court. For the circuit court, they're $80. So remember, all these have to be on conviction. I forgot to mention that before. You have to be convicted of or plead guilty or found guilty in order for a court cost to be assessed. Traffic cases have the same, including parking and impound cases. There's some exceptions to that, but it's generally $22.50 also for regular, what we call regular court costs. And then there's additional court costs, which most judges describe as CICF, and we'll get into that in just the next slide. But for the circuit court, it's $45, and for the district court, it's $35. And I've mentioned this $3. So CICF, that $45 or $35 has a part in the statute that says for criminal, and that's the criminal part. And then it says for offenses, which are all traffic cases, that's where the $3 comes in. So I wouldn't assess on a traffic case the $35, I would assess the $3 as additional costs. So you can we kind of gave an example. So if there's a conviction of assault in the second degree in the district court, court cost would be $22.50. And then the CICF, the additional cost of $35 for a total cost of $57.50. In the circuit court, it's that court cost of $80 plus the additional cost of CICF of $45. And so Again, going back to payable traffic, just so you understand, it would be there wouldn't be that $35 there. It would be the $22.50 plus the $3. And in the circuit court, it would be the $80 plus the $3. So here's just one other vehicle.
Right, so an example of a combined case in the circuit court where you have a payable traffic and a criminal case. It's when you have a maybe a traffic stop where you have an assault, speeding first, assault, conviction of a DUI. You could have an $80 court cost, additional $45 for the second degree assault, and then the $3 for the speeding. So a total of $128 in cost in circuit court.
So again, you have two choices. You can either prepay the traffic offense, or you can contest the case at trial. You can also plead guilty with an explanation if you want, but you would come to court on something like that. We're actually working on a system to do that remotely. And I hope to come back to you, probably not this session, but by next session, with an operational system that allows people to do that. We're getting closer. We've already selected a vendor and we're working on it as we speak. Whether or not, and this sounds a little odd, whether or not you go to trial or not, court costs are assessed of $22.50. So what we do is in the prepays, if you look at that booklet that I set around, if the prepay is $100, we don't charge another $22.50 for prepays. It's just included in the $100. And I take that into account in setting that prepayment amount. And it's just taken out, but it goes to the general fund, as does the fine go to the general fund. So not quite sure why that's the case, but that is the way the statute reads. It all goes to the general fund in the district court. Indigency. So there's two boxes when I'm sitting up in court, I have a docket sheet that I'm looking at, and it has all the possible outcomes that could be there. And there's two boxes there, one for costs and one for, among hundreds of boxes, one for costs and one for CICF. And if I'm going to waive those costs, I have to do it pursuant to statute of 7405 in courts and judicials, and then rule 43353 in the Maryland rules. It's particularly strenuous with respect to the CICF portion of the costs. I have to find indigency, and I have to make a specific finding that that's going to last for more than 12 years before I can waive CICF. And so you'll see in the revenue numbers now where judges are more likely to waive regular costs than they are to waive CICF, because you have to make that specific finding. Where do the monies get dispersed?
So this is an important slide. So this in a nutshell is everything that we have already spoken about the costs. So if you look in the slide, you see that the cost for the district court, $22.50, goes to the general fund, and the $80 circuit court fee. And then you have those additional costs, which is $35 in the district court, and then $45 in the circuit court. And so the 45 and the 35 additional costs are used solely to support the victim services. So in this slide with the definitions, with both the circuit and the district court collect the $20 for the CICF, which is the Criminal Injuries Compensation Board, which is administered by the Criminal Injuries Compensation Board, and that's pursuant to statute 11819 in the criminal procedure article. And then you have the $12.50 in the district court and $22.50 in the circuit court. Also by statute with criminal procedure 11916, which is for the state victims crime fund. And so this provides funds for service providers, nonprofits, and local government agencies. And this also is where you have the $1.50 and $1.50 for the CICF and VCF for the traffic cases, so your payables. Then the last fund of this is the $2.50, which is for the Victim and Witness Protection and Relocation Fund. And this is also pursuant to statute criminal procedure 11902. So this is the $2.50. So this is what makes up what we call the additional funds, which is 35 in district court and 45 in circuit.
So fees. It's back to you.
Okay. So there are additional fees in the circuit court that are added to the cases. So including the $80 court cost and then the additional funds. Some counties have the attorney appearance fees, which is $10 attorney appearance fees, which is found in Courts and Judicial Proceedings 7204. Those are collected and dispersed to various law libraries for the county. And then you also sometimes have a share of service fees, which is pursuant to statute as well, where that's dispersed 95% to the sheriff and 5% to the general fund.
So revenue. This is a combined statistic for fiscal 22 and 23 between the district and the circuit courts. So you can see that I'll just use fiscal 22, we had fines totaling, this is actually collected revenue, okay, of 27 million plus. Out of that, the regular court cost, the $22.50 or the $80 was 8 million. The CICF and the victim crime fund is about 3 million, and that totals 39 million. Fiscal 23, it was about 33 million total. A lot of that is driven by traffic and prepayable in particular traffic. So this is a pie graph that shows the percent of eligible cases which receive what we call a financial adjustment. And that can be a judge waives a fee, a judge suspends a fee, or kind of those terms are somewhat interchangeable, but not. A waiver of fee would connote more that it's never going to be collected again. A suspended fee would be that there's a possibility for it to come back. But typically judges use those interchangeably to mean that you're waiving a certain portion of the fee. So again, these are of cases that had a guilty disposition. There was about 9% in both fiscal years that had some type of adjustment to them, either a waiver or a suspension of costs or fees or fines. This is specifically to the district court. It's, again, kind of the larger driver of the numbers because of the volume that we do in the district court, particularly with respect to traffic. And then this is by case type, and you can see criminal, there's a little bit more. Jailable traffic is the highest at about 23% of the cases have some type of adjustment to them. And then payable traffic, again, because prepaid, there's really not an opportunity to waive anything. They're just paying the money, right? There's a set amount, they pay the money. There's really not any judicial intervention to that particularly. So there's much less waivers, as you can see. And then that's fiscal 23, and they're somewhat consistent. I mean, they're within the range. They don't change very much from year to year.
So with the circuit court, with the guilty dispositions, for fiscal year 22, there was about 24% that had that had a judicial waiver, and then in fiscal year 23, went to 27% had a judicial waiver.
And then these are the total amounts of the adjustments. So fines, there was a little over $5 million of fines that were either waived or suspended. There was 820,000 plus that regular costs that were waived or suspended, and additional cost CICF of 258,000. You can see the numbers for fiscal 23 also. Some of that is caused by, in the district court at least, where if you were to have multiple traffic citations that you would plead guilty to in court, suppose the person pled guilty to 4 different citations, I'm not going to impose court costs 4 times. I'm only going to impose them 1. But you have to do something on the judgment sheet to give the clerk the understanding of what you're doing. And so you would waive costs in CICF on those other 3 citations and only impose them on the 1. So that's where some of this comes from. How to pay. So there's a number of different options that you have to pay. The most frequent one that most judges use are deferred payments. So when you come into court, typically it was my habit and a lot of other judges' habit to ask, I fine you $100 plus court costs of $57.50. Can you pay that amount today? Because it's actually due that day. And invariably they say, no, I can't. And then the next question is, well, how long do you need to pay that? And they say 30 days or 60 days. And you say, fine. That's fine. I'll defer this for 60 days so that you can pay it. If there's a problem, send in a motion to me and we'll consider it, but try to make it paid within those 60 days. And that's the most common and frequent way that most judges do those things. There's for people that are incarcerated, typically the fines aren't going to start, or the costs or fines aren't going to start until after that person's released, and you'll check the box on the form that says upon release, and that's when and it's usually through parole and probation that would collect something like that. And then finally, payment plans are authorized. They're based on 7504.1 of the Courts and Judicial Proceedings article. It's outlined on the traffic citation. One of my responsibilities is to work with the MVA and the police to provide a uniform traffic citation and criminal citation. It's packed with information, but it does include an option to enter into a payment plan on the ticket, and they can choose that option if they want to. Unfortunately, the default rate for these payment plans has been awful. In certain months, it's increase of 100%. And you may ask how it could be over 100%, because I asked that same question. People can apply, they can apply for the payment plan default, and the law allows them to reapply again. I tried at one point, originally we had said a 10-day grace period when they asked for it to pay. And I noticed the default rates were bad. And then we increased, I thought maybe people didn't have enough time to get that first payment up. And so maybe they needed a little bit more time to do it. So I increased it to 30%. And that did not improve the situation, unfortunately. In fact, it went down a little bit. So that's the presentation. We'd be happy to answer any questions as best we can.
All right, I see. I'm going to start over here. Delegate Kaufman, then Williams, then Cardin, then I have a couple.
Okay, thank you both, Your Honor and Madam Clerk. It's a pleasure to be with you and to be back with my colleagues. It's great to see everyone. My question, I have two questions, sir. Whether or not a fee is waived, is that at the sole discretion of the judge, or do you have a set criteria, a criterion where you say you can waive it if the following things exist? Sally lost her job or whatever. My second question, and if that's okay, Mr. Chair, is do you feel that the significant amount of revenue that localities and the state generate from these fines and fees is a disincentive to waive the fees, or does it not enter your minds at all?
So as to the first question, Delegate, the fines, there is discretion among the judge to do what they want with fines. You can increase it above the prepayable, which is rare. The docket sheet prints out the prepayable number, so you know what the prepay is. Most judges stick to that number. Most judges give some.
Sorry for interrupting, but it means they pay in advance? Okay, thanks.
Pay in advance is they just pay, but these the number that would be prepayment prints out on the docket sheet if people decide to contest the case. So I know what that number is when I'm sitting in court. A lot of judges will give a break to people, but it's within the discretion for fines. With costs, as I discussed before, you have to make specific findings of indigency in order to waive cost.
And my second question about the incentive?
That I can only speak for myself, Delegate, and that doesn't come into play. I follow what the statute and the law say, and I try to, impose justice as fairly as possible. It's one thing if a person walks into my courtroom with a handicap sticker that's fallen down and they have a walker. It's another one with a person doing 120 miles an hour in a car. I mean, those are two different situations where I would probably fine nothing for the first instance and probably fine a considerable amount for the second one.
Well, I thank you. Maryland is lucky to have excellent jurists like you and excellent clerks like you, Madam Clerk. Thank you, Mr. Chair.
All right.
Thank you,
All
Delegate.
right, now,
That was very nice.
Delegate
I think
Williams.
that's the nicest thing anyone has ever said.
We're starting off so well this year. It's fantastic. Delegate Williams, please.
That is helpful. Thank you so much. And my question, just to kind of piggyback on some of the questions that Delegate Kaufman asked, with regards to the payment options or the waiver of some of the fees, do you also keep track of requests that are made but are in turn denied? And if so, what is the rate of those denials of those requests?
That's, to my knowledge, that's not a data item that we keep track of.
Okay. And then my other question is, I know that there are opportunities where individuals can request a waiver of the fees, especially with the filing fees and things like that. But there's a form, it's my understanding, there's a form that one has to fill out, and you mentioned that there are income requirements that one has to meet. Correct.
So you're now over onto the civil side of filing fees, and we were asked specifically to talk about criminal fees, I believe, here.
Okay.
But yes, there are. The district court particularly has purposely tried to keep our filing fees low because we're derived from the people's court, and we, particularly during my administration, I have not wanted to raise those and haven't. And so they're purposely low. Like to file a small claims complaint, it's $36. For large claims, it's $46. But you can file an application to waive those fees.
Okay. And then for nonprofit organizations that represent indigent individuals with the court, are those fees automatically waived? And what's the process for those? And for those?
They are, and that's
Nonprofits.
defined by statute also, and in that it's really just the first time they need to let us know who they are and under what authority they have, and then from then on out, they're automatically waived. We don't assess a fee on that.
Okay. All right. But it's not automatic just because they're, say, from Maryland Legal Aid or Child or CLS or anything like that.
Well, it is I mean, if they are who they say they are, then there's not, we won't, there's no discretion on our part. We grant the waiver. So in that sense, it's automatic.
Okay. Alrighty. Thank you.
I'm going to ask a couple of questions, then I'm going to keep sending it around the horseshoe. The emergency medical operations funds, does part of that money go to shock trauma? I recognized a couple of those funds, and I wasn't sure whether some of that was in part how we fund shock trauma. And if you don't know, I have a sense I'll probably hear from shock trauma here shortly.
Right. I do not know. It says after a total of $2 million or $20 million has been distributed to the Volunteer Company Assistance Fund, 100% of the remainder goes to the Emergency Medical Systems Operation Fund. Okay. It used to be at one point, the $7.50 was going to the Maryland State Police for the helicopter fund.
Right.
That's when I first started on there.
Okay. The other question I want to ask is about parole and probation fees. We don't have P&P here today. We're not able to get them here for this today, but it's a big part of one of the questions that we're dealing with. Your Honor, can you help the committee understand when a court can waive parole and or probation fees?
So the court has the ability to waive those fees, the supervision fees. And then it's kind of as part of the sentence, you can make, if you're going to put someone on parole or probation, you can make the fine a condition of parole or probation, but you don't have to. It's up to the particular judge. I think a lot of judges do. But you also have the discretion to waive those fees also.
And so, and again, it's based on a finding of indigency, correct?
That would be correct.
And so if somebody is represented by the Office of the Public Defender, would that automatically trigger an indigency finding?
No.
No. Okay. That has to be a separate indigency requirement.
It does.
Okay. Delegate Cardin, then I'll go down.
Thank you. Thank you, Mr. Chair. Thank you very much for being here, Your Honor, and Madam Clerk. First of all, having clients who are constantly dealing with these fines and fees, I want to say that you do make it easy for people to know exactly how much they have to give, and the complexities of where it's distributed is not necessarily on these individuals, and so that is good and helpful. And I ask you to keep on talking to MVA and whomever you need to make sure that that's clear. Two quick questions. First one is, it seemed like in one of your slides, you had revenues for FY 22 and FY 23 up. I'm looking at it here. I know you might have it. 22 was like 39,280,000 and 23 was 33,900,000. It went down by like $6 million. And the question is that because there is less enforcement on the roads because a lot of these are from traffic? And if so, is that an issue that you hopefully you're looking at to see about making sure that we're both keeping the roads safe and making sure our revenues are predictable? That's question number one.
So as to your first question, it may be partly due to enforcement efforts. That's hard for me to see other than through the volume that's coming through, but part of it was definitely related to pandemic. In the phases that we went through in the pandemic, we had a 5-phase approach to the pandemic where we would go from phase 1, which was the most restrictive. We never closed. We just went down to our core functions of criminal cases and domestic violence. And then each additional, we would bring on more. The last 2 that were brought on were payable traffic and landlord tenant. And that was because they're the highest volume in the district court. And of course, we were trying to keep people segregated at that time and make sure that we didn't lose court systems. We never lost a court system during it. Was my kind of greatest nightmare that we'd have to close because of a COVID, and we never did. So 2022, we were kind of in fiscal 22, we were coming out of it. We were back in phase 5 for extended periods of time. And so we were catching up, trying to catch up on our arrearages basically from what had built up over the prior 1.5 years.
Okay.
So I think that explains the majority of it.
Thank you. That actually leads to question number 2, which is the payment plans, which have seemed to be somewhat problematic or somewhat unsuccessful in making sure that they're working out. And the question is, have you considered, do you have staff to deal with this and follow up with people on payment plans, or considered contracting out as a possibly revenue positive way of dealing with that?
Well, what we do is send out a notice 2 times. Is that right? Or we send out a first notice saying, you need to get this caught up. And then we send out a second notice. And then typically we would then send it over to CCU for collection at that point.
Okay. And okay. All right. Thank you. Thank you, Mr. Chair.
Thank you, Mr. Chair. Actually, you just answered my first question, which is if you are pushing these cases into collections. The second question I have, I'm sorry, I know this is trying to be about criminal fines, but some of the tables you're showing are about broader topics. And so I'm curious if the payable traffic includes photo and toll violations in it.
Those are different.
Okay.
So right now, every traffic, a movable offense, right, where you're on the traffic and a police officer writes you a citation, all of those come to the district court. And so we have them, a feed comes over, we know what they are, and then anyone that asks for trial, we do. Where it's like a toll violation or a red light camera case, those are county-based, and they only send us over the records that are actually have requested a trial, and the monies aren't, they collect the monies before trial. Normally with a traffic ticket, if you want to prepay, you just pay us. But in those instances, they'll pay the counties, and then only the cases that go to trial are given to us. And then we only really have basically jurisdiction of it for that one day that it's in trial. And then it goes back to the county for anything else. And we impose the $22.50 court costs on those. I believe there's a couple exceptions to that where it's, I want to say the intercounty connector is only $5. I think there's lesser ones. And
Wait
then
a second. So
maybe $3. Maybe I don't quite know the number, but there's some associated cost, but that's payable to the county.
this is a stranger answer than I was anticipating.
Yeah, it's
So
It's
are you
challenging.
saying that when we have something like an ICC toll violation docket, you don't get the fine revenue or the cost of administration of the appeal, but the district court has to handle an in-person appeal of whatever the $1 ICC toll violation and doesn't see any of the money on it.
If it comes to court that day, and if we find the person guilty and they pay that day, then we do get to keep the court costs. But otherwise, it's payable to the counties. And it's,
I have wondered whether this process pays for itself. Because I remember you came in asking for extra judges partly because of this kind of docket issue. And I know those cases end up at the CCU also. Anyway, sorry, I don't mean to distract. That is very that is very interesting. So the CCU one is actually the one that sort of jumps out at me when any of these cases end up at CCU. I mean, if they're coming in through the judicial system, especially as part of a criminal, you know, a larger how to approach a defendant and you know, rehabilitate or whatever. I wonder if any analysis goes in, you know, with collections from that aspect. Or is that just sort of the end of the story? And I guess, do you have any numbers on how many cases are going into collections?
Yeah, I don't have them right here today, but we can supply you with that information. But you know, typically the judge is setting a fine that they find appropriate for the offense that was created, and then you know it's up to the individual then to petition the court. You know, I do make that finding initially, but if someone were to say, you know, to write me a motion that would say, look, I'm having a hard time paying this, I'd say my next question would be, how long do you need? You know, you don't want to leave people forever because then they just won't pay it. But
Okay.
and it's all, you know, it's all by statute. I mean, it's the statute tells us what we're supposed to do.
All right, thank you.
Delegate Embry, then Tolles, then Phillips, then we're going to wrap this up because it's 1:40. Everybody's Delegate Embry, well, not totally the same. Particular part. Delegate Embry.
Thank you, Chair. Thank you, Your Honor. Could you speak a little bit more about the process of determining indigency and what evidence is required at that moment? And then if there's ever, I know you can't speak for every judge, but if there's some question, if the decision is delayed for the defendant to have an opportunity to provide documentary evidence.
You can certainly do that. And I've had that request made before that they just don't have the documentation to do it. But it's a pretty high burden in my mind of the person is going to have to be indigent for 12 years. And it becomes a civil judgment if they don't pay that, in the statute of limitations for non-state of Maryland judgments is 12 years.
And
so there's a committee note in the rule that goes along with the statute that speaks to the logic behind that. And it's included in the small print in the presentation that we gave.
Okay, thank you very much.
Delegate Tolles, then Phillips.
Thank you, Mr. Chair. Good to see you again, Judge Morrissey. Long time no see. The question I have, and a great Supreme Court meeting on Friday in the county. So thank you for that.
That was wonderful.
It was great, and all those youth were there to witness. But that's not the question. Isn't that so? That's question number.
That is so. For those that don't know, the Supreme Court for the first time in 100 and some odd years sat outside of the city of Annapolis based on a finding of good cause. And they have decided to sit in each circuit in a local high school in that circuit, the first of which was in Prince George's County at Henry H. Wise High School. It's a beautiful school, by the way.
Thank you. It was in District 25, and we thank you, Delegate Robeson, and I thank you. So the question I have is in reference to the cost of witness protection fund. Do you know how much has been sort of collected from that fund? Maybe what's like the annual amount that is collected?
We can get
Yeah,
that.
we can get that. I don't have that broken out right here today, but we can certainly supply that
Okay.
for you.
And generally, is it used, I'm assuming that when, I guess, in criminal cases, if you're trying to keep the witnesses hidden or safe. I know there has been previously there has been witnesses that just don't want to go in hiding because they just feel like they don't want to do that. So I just kind of want to delve more into that witness fund, $7.50 doesn't seem like a whole lot, but I guess it's per ticket. So I'm just curious to know.
Well,
what-
the
$2.50.
$7.50 is for VCAF, which is the firemen's and people like this. It would be the $2.50 out of the $35 or the $45 that would go to that. But those are, we could show you what we send over, but how it's spent would be outside of that's with the state's attorneys or the sheriff's. I'm not exactly sure.
State's attorneys.
State's attorneys, yeah. Okay, so just curious to know what the annual
Sure.
amount, you can get that to me. Thank you, Mr. Chair.
Chair, thank you very much. Thank you to the Honorable Judge Morrissey and to our clerk there. I've got a couple of things, and real quick, Delegate Moon asked a question and I'm curious about something as a result of his question. Are the fees and fines that are received through MDTA, which you have to potentially adjudicate, or through like the Maryland Aviation Administration Police, are those then received by the counties? How does that differ, or does it differ?
So I don't think I've ever seen an aviation police case before. But it would be like red light cameras, speed cameras, parking ticket typically. Those are all local revenue.
But the toll booths are not, right?
The toll booths are treated the same way. Yes, they're local.
Okay. All right. I was just curious about that based on
There's
that
a number of
conversation.
jurisdictions that have toll booths ending in their jurisdiction where the gantries are.
Okay.
Queen Anne's is one of them. In fact, I was, I don't, never mind. I was, when they were moving the tolls away from the Bay
To
Bridge,
this side.
I was assured by the MVA at that time that they weren't moving the gantries because it's important. Where all the tickets go is a large county like Anne Arundel or a small county like Queen Anne's. And I drove during the pandemic. I took my wife and children over to one of the beautiful parks in Queen Anne's, and I got out of the car outside the gantry because it was now over on the Queen Anne side. And I immediately called the MVA to find out what was going out. But
Okay.
apparently I was the last person to know, and my court had already adjusted to it. So it all went well.
Okay. All right. In here on one of your slides, I think it's 20, attorney appearance fees in some counties, courts, and judicial proceedings allows for attorney appearance fees. I don't do circuit court work, but why do we allow that? Do you know what the history is about why we allow in some counties and not others?
It's per statute. It's $10 per attorney or the firm. I think that did we produce the history paper?
No, but we have that. We have
Okay.
an attorney general's opinion from many years ago.
What
That's all.
counties do that?
I believe all counties except Montgomery County.
Interesting. Okay. And this is my last one. Do fees and fines and the potential waiver or adjustment of fees and fines impact plea bargaining in traffic cases specifically and just criminal cases more generally? Do they have any impact?
So in payable traffic, usually the state's attorney's not in the courtroom, and it's really.
But if it's a serious traffic matter, right?
Generally not. I mean, that's not a large consideration. Where it's a jailable traffic offense, the issue is, are you going to give them a probation before judgment, or is there going to be a suspended sentence, or are they going to do, jail time on it? That's really the driving factor on it.
Okay. Thank you.
Okay.
All right. Thank you very much, Your Honor. Thank you very much for your presentation here today. That concludes that first part. We're going to hear next from Maryland Legal Aid. And while Hunter is setting this up, I was wrong to not mention that we have a new member of the committee who we can who is welcome to be with us, Delegate Robertson from Prince George's County, who is joining us now, and this is his first briefing. For those who are getting ready to tune in because they're expecting the Juvenile Justice Channel, we're going to be getting to that as soon as we finish these next two presentations. So we're going to hear from Legal Aid and from Somil Trivaldi, which I routinely will screw up. The committee should know that he is not been feeling well. And so he's doing this virtually so that we do not feel well. Following this, we're going to have presentation from several members from BUILD, from Baltimoreans United Leadership Development. So for those watching at home, my estimate, please, committee, let's try and hit this, is I believe we will end up starting at about 2:30, maybe a little before that. But I would just encourage members of the committee, of course, to ask questions, but to try and be deliberate about the questions that you're asking. Did I mention that they should be questions? So if we've got Samil, he's on? Okay, let's go ahead.
Thank you, Chair. Hi, everyone. Thank you to the committee. Thank you to the judiciary folks who are here and to BUILD for having me. I do apologize for not being able to be there in person, but I figured you didn't want me there in person given my positive COVID test. So if I start uncontrollably coughing at any point, just assume I said something imminently profound and we can move on. Again, my name is Somil Trivedi. I'm the Chief Legal and Advocacy Director at Maryland Legal Aid. And before I launch into my presentation, I just want to remind all of you what it is that Maryland Legal Aid does. So Hunter, if you wouldn't mind going to the next slide. And I know many of you are supporters of us, so you don't really need the reminder, but it's important to give context for my comments today. Sorry, if we could hop back one. Thanks. Yeah. So who are we and what do we do? Maryland Legal Aid provides pro bono legal services in civil matters to over 100,000 low-income Marylanders and their families every year. That's civil, so I'm not here to necessarily comment on the criminal pieces that Judge Morrissey talked about a moment ago, though we touch criminal matters indirectly in ways that I'll talk about in a little bit. But our bread and butter is people's fundamental needs to get by: housing, foreclosure, consumer protection, public benefits, Social Security, Medicaid, divorce, custody, domestic violence, children's rights, and, as I mentioned, criminal record expungements. That's what we do for hundreds of thousands of folks every year. And as a reminder of our income eligibility, it's extremely low. It's $18,000 and change per person and $37,500 for a family of four. And I say that to say that all of our folks uniformly are indigent and cannot afford many of the financial obligations that bring them to court, much less the financial obligations that are imposed by a court or over the course of court proceedings. So if we go to the next slide, and this was touched upon in the last little bit, but I want to say as context that it is true. Court Rule 1-325 allows for a waiver of appearance fees and filing fees on the front end, and then costs on the back end. And we appreciate that. Our clients couldn't afford those fees, and we would have to take it out of our money, and we can't afford very much either. And so that as the default presumption is incredibly helpful, and we want to thank the judiciary and everybody who provided for that. It makes us a leader in that realm. However, I do have to sort of gently correct the record that Judge Morrissey, who is a partner of ours, created in response to Delegate Williams' question, which was whether these waivers are automatic or whether the judiciary has any discretion in granting them. So yes, it's true that Maryland Legal Aid and other legal services providers are mentioned as being eligible for waivers, but it is not indeed automatic in that we do have to file for them. And that's why I've included this cheeky picture of being buried in paperwork. It does often take time for us to write the waivers and get them granted, which can often result in a delay of service or a delay in the case moving forward. And, procedures vary pretty significantly from jurisdiction to jurisdiction, particularly on final costs. So we have fewer problems with front-end costs like appearance fees, although I would rather that we not have to file for them at all. When we file for them, they're almost always granted. Final costs or intermediary costs, like costs for recordings and transcripts, take a lot of time. We've got to prepay, and that means cutting a check from our finance department and things of that nature. And they are, in fact, not always waived. And so in anticipation of this testimony, I collected some stories from folks across our organization. So in August 2022, we had a family law protective order hearing where we needed an audio recording of a particular hearing. We ended up paying a fee and it was not waived. We had an appellate housing case last year in circuit court in Baltimore City, and the costs at the end of the case were not waived. There's also vagaries like sometimes we have post-judgment actions, and even though our attorneys have been in the case the entire time, they're forced to reappear, reapply for the waiver several times often, and even one case where an attorney left for another job while a waiver application was pending, and since it was never resolved and the attorney moved on, she ended up getting a call from a collections agency in Chicago over it. And so again, while we appreciate what is on paper, that these fees can be waived, that's not always the reality in practice, and they are not always, in fact, waived. Okay, if we could go to the next slide. Okay, so this is where Maryland Legal Aid's work touches on criminal fines and fees through our expungement work. So we represent tens of thousands of folks in expungement proceedings every year. And first of all, there is a filing fee there, and it's based on each conviction, which can really add up. Again, it is waivable, but time-consuming to file for waivers, not guaranteed that the waiver will be granted. And more significantly, there is no expungement available if there are unpaid fines and fees from the underlying offense. And then if folks are on supervision, probation or parole, those supervision fees, which can often add up into the hundreds, which our folks cannot afford, that can be grounds for a supervision violation, which, based on a case from last year, Abhishek, makes the underlying offense not expungible in perpetuity. So those are some ways where unaffordable fines and fees can bleed into folks' civil work and can undermine the sort of purpose of expungement. Next slide, please. Okay, and then to widen the aperture just a little bit, if you don't mind, there are also costs associated with litigation that are not court-imposed. I don't want to imply that they are. We've covered the court-imposed costs. But things like the cost for a landlord to redeem possession in cases where a tenant is unable to appear, this can often be $70 or $80. That gets shifted to a tenant in a system where we know it's extremely difficult to appear, where notice is often not effectuated, and things of that nature. And that just creates an unpayable financial burden for a lot of our housing clients. Similarly, we often get assessed appeal bonds that are higher than our folks can afford. That essentially eviscerates the statutory right to an appeal. Also, similarly, a lot of our clients get their driver's licenses suspended for child support arrears, which is only counterproductive and deepens the original poverty when, of course, they couldn't pay and now they can't drive to the job that would have allowed them to pay that child support. Next slide, please. Okay, so I've moved quickly. I hope that helps the committee stay on track for their next hearing, but I did want to get to some solutions, then of course open the floor for questions. And so my one proposed solution would go to Delegate Williams' question, which is, let's make it truly automatic and truly prepayment. The waiver of all fees and costs, including for things like recordings and transcripts and other final costs, so that we don't have to go through all of the time-consuming paperwork, so that we don't run into these exceptions. And again, I grant that they're exceptions, not the rule, but we don't run into these exceptions where fees are not in fact waived and we have to eat the cost, which is to say the taxpayer has to eat the cost because we are funded by you. Also, I would appreciate from the judiciary and maybe this body greater scrutiny of monetary burdens that impede access to judgments, like that cost to redeem that I mentioned, or like appeal bonds that nobody can afford. And finally, and this will seem self-serving because it absolutely is, but I have to mention it because it's relevant. Funding legal services is a net stimulus for Maryland. It reduces state expenditures on things like homelessness and benefits and prevents the need for cases and therefore fees in the first place. So if we can keep people out of the system, we won't have to keep doing these complicated calculations and go through the process of waiving fees. because we'll be more effectively solving poverty in the first place. So I appreciate it. Thank you for indulging me coming in by Zoom, and I'm happy to answer any questions.
Delegate Kaufman.
Yes.
I'm sorry, if there's a question being asked, I can't hear it.
Yeah, I'm waiting for the mic to work.
Oh, sorry about that.
Yeah.
Okay, great.
Okay, thank you, sir, for coming in, and may you feel better. My question is, I certainly sympathize with your point regarding people can't pay, they get their driver's license suspended so they can't get to work, which makes it harder to pay, or probation fees that make it harder to pay. And I'm not in favor of criminalizing poverty, but I do believe that when you do something wrong, there should be consequences. So does legal aid have alternative consequences they could recommend, given that the fines you say are too steep for a lot of your clients?
Well, I appreciate that question, and I think the consequence is the original consequence. So in the criminal setting, and again, I'm not here as a representative of the criminal justice system, but it's not as though we are waiving folks' original sentence. These are fines and fees that are imposed by the court on people who can't pay them. And we already have a criminal justice apparatus that imposes consequences that are decided democratically and adjudicated by judges and argued by prosecutors and public defenders. So adding the additional penalty of monetary burdens and then the additional penalty of sometimes lifetime records in a state where we've decided that expungement is necessary seems additive and duplicative and unnecessary and counterproductive because folks can't get back to their lives. So that's what I would suggest.
Thank you, Mr. Chair.
Delegate Tomlinson.
Thank you. I just wanted to make sure I understood that correctly. Are you there? Okay. So to make sure I understood that correctly. So as far as expungements, bless you.
It wasn't me.
Are you saying that there are situations where somebody will be found guilty, they'll be put on unsupervised probation. It will be a crime that is expungible. However, they will break probation and therefore they will no longer be able to get that crime expunged. Is that correct?
That is correct under an appeals court, intermediary appeals court case as of a couple of years ago. And you've hit the question on the head, which is the underlying crime is expungible, but violating the probation on that crime, which can often be not for a reoffense, but a violation of the terms of probation, which can often be based on poverty or homelessness or things of that nature. And so separate and apart from this hearing, we think that a fix to that case would serve a lot of our clients and serve the purposes of expungement.
And you're saying by violating probation, it could have been, they failed a urine test, but also it could be where they just didn't pay the cost of the unsupervised probation?
That's right. As long as a judge determines that probation was completed, quote, unsatisfactorily, and that could be for any of the reasons you just mentioned, yes, the underlying offense is not able to be expunged ever.
Okay, thank you.
Thank you.
All right, we'll go to Delegate Williams, and then I think we're going to need to move on.
Okay.
Delegate Williams.
Sure, and just to piggyback on Delegate Tomlinson's question, it wasn't mentioned in the previous presentation about the unsupervised costs, and I was just wondering if you could just elaborate so everyone knows what we're talking about when we're talking about unsupervised costs in terms of parole and probation or other things. I'm assuming you're talking about like ankle monitoring and things like that.
That's right. Again, I think the OPD would be a better spokesperson for this because they really deal with these costs every day. But yes, I mean, there are sort of set costs for entering into supervision. Then there are additional costs for things like drug testing and ankle monitoring and things of that nature. And I will say that unfortunately, legal aid does not have access to the JIS system. So we're not often able to tell why probation was ended unsatisfactorily. Again, OPD does have that access. The state's attorney does have that access. But it is absolutely possible. And we know that those clients are almost by definition indigent. And as I said, as long as a judge puts unsatisfactory on the end of that probation, that's it.
Gotcha. And there isn't a mechanism to request a waiver of those costs?
If so, it would be in the criminal system. And again, I'd have to point you to OPD.
Okay, thank you.
Thank you. I appreciate the question.
Vice Chair.
Thank you, Mr. Chair. Just a quick question. I want to make sure I understand. So if your clients currently have to, in order to qualify for MLA, have to be within the 18,000 annual or family of four, 37,000, am I hearing it right that essentially they are already well below the well within the poverty line, that it is a request that if they are represented by MLA attorneys, that their filing fees should be exempt? Is that the ask?
Yes, Delegate, that's exactly the ask. And, Chief Judge Morrissey said that, if you're a repeat player, then we'll only ask you once. And again, respectfully, I have to say, that's not our experience. We have folks that have been here for decades, going to the same judges and the same kinds of matters, and they still have to file the paperwork when everyone knows who our clients are and who we represent. So I appreciate the question.
Okay, thank you.
All right, thank you very much. We're going to keep moving here, and we're going to ask for our next group to come forward from Baltimoreans United Leadership Development. Thank you very much, Mr. Treveldi, for speaking with us today. Come on up. We're going to hear from Minister Thomas Anderson, Alicia Shaw, Michael Barton, and Rebecca Diller. Are all four here or only two?
Two and
Are they-
one is
one's
coming via
virtual?
Zoom.
Okay, one's virtual. We'll add them in. We're gonna try and come to a conclusion around 2:30 if we can, but this is an important issue, so we'll take the time that we need. And we have Rebecca Diller. We have Rebecca Diller on. Okay, that's fine. Who'd like to go first?
I'll go first.
Sure.
First, it's incumbent upon me on behalf of Build and Turnaround Tuesday to offer our condolences to you for your loss, the loss of your father. Secondly, thank you for the opportunity to speak before you here concerning the issue that's in this committee today. My name is Thomas Anderson, and I spent 22 and a half years incarcerated in the Maryland State Prison System. I'm a representative of Build. Build is a broad-based organization comprised of more than 40 religious congregations, nonprofits, and schools. We've been in the community since 1977, and we are actively engaged in issues such as housing, education, criminal justice, and jobs. In fact, our most recent encounter was a large campaign here in Annapolis where we were able to garner $1 billion to go towards the rebuilding of a third of Baltimore City's dilapidated school system. With that said, about 4 months ago, Build, in conjunction with Turnaround Tuesday, we had an initial conversation with many of the people who lived in the community concerning parole. And we found that fines, fees, and monitoring negatively impacted their sense of community. It limited their opportunities, and it subsequently hindered their level of equality. Then we took a survey of over 200 people, and we found that the issue permeated our communities, and it weighed heavy on the economic stability of its victims. And so we juxtaposed those surveys, and we facilitated two community meetings, and we allowed people to get involved in the conversation. And in fact, the committee chair, Mr. Clippinger, graciously accepted our informal invitation, and he came and he gave ear to our concerns. We are now here in a more formal capacity to make our concerns known in hopes that something will be changed in this regard. We believe that legislation should be drafted and passed to end parole and probation fees here in the state of Maryland. We believe that to be in line with many of the surrounding states that encompasses us. This will make it easier for those returning citizens to be able to get back on the right track and to provide them with the resources that will enable them to take care of themselves and their family. Similarly, the committee should address the large fees that's related to ankle monitoring. Now you are about to hear two testimonials of the negative impact that the present legislation has on the lives of those who are on parole. Thank you.
Good afternoon. My name is Michael Martin Abdul Umar. I'm leader with BUILD and associated with Maryland Criminal Justice Reform, Maryland Cure, and a grateful returning citizen. Recently, I was released after 145 days after serving 32 years, 9 months on a life sentence. It was truly disheartening and baffling to know that I was subjected to the mandated parole fees associated with being on parole. I only was released after engaging in long protracted litigation with the Maryland Parole Commission in a matter in federal court. After being released, I was shortly advised that I would have to be subjected to paying $52 monthly in order to be on parole for the lifetime of parole supervision that I'm mandated to be on. I found this truly amazing, the fact there was no assessment ability to assess my ability to pay, oftentimes created enormous hardship, at times have me to choose between eating and paying my fees. Of course, I chose the latter over the former frequently. I found it to create enormous hardship to such an extent that I brought it to my parole agent's attention on the matter, only to be told by her that she advised that I do what I have to do to come up with the fees, even if it means panhandling. I found that totally amazing that I was told to actually break the law in order to make sure my fees were satisfied in this matter, which subjected me possibly could be returned back to custody for breaking the law. It's sad that it created such a hardship that make one actually consider engaging in recidivism just to maintain his freedom and stay on parole out in society. I'd like to speak now on the behalf of Alicia Shaw, who's absent due to health issues, and tell a little about her situation. She also served 16 years at 18 years old for a crime that she was convicted of. She did all the right things during her incarceration while incarcerated, including getting her GED, earning 71 credits, towards her college degree. When she finally was released, she used all the money that she saved towards housing to pay rent at her sister's house at $600 a month, till she finally got a job, which only allowed her to make $9.39 an hour. She saved her money for her job and still neglected to paying her fees because of her ability to try to maintain housing, because her sister's lease was coming to an end, and it was important to her to maintain housing and an address that was listed for parole approval. Now her parole is coming to an end. However, she has thousands of dollars of fees in debt because of the parole fees, which she was unable to pay. It lingers over her head. She's worried every day about this and the debt and whether she might be returned back to prison eventually because of it. It's millions like herself and I who are struggling and might be tempted by the easy money on the streets to satisfy these parole debts. At no point was her or I ever advised of the waiver which we was entitled to submit to ask for waiver of the fees. These are just two stories out of thousands, many more. The practice of charging the $52 per month parole or probation fees should be ended. It's clearly inimical to encourage and promote the successful rehabilitation and reentry back into society for us returning citizens, and could dangerously promote recidivism. Thank you.
Ms. Stiller will be coming on virtually.
Good afternoon. Thank you for having me here. I co-wrote in 2009 an in-depth report on the parole supervision fee as part of an effort at the Brennan Center for Justice. to look into how this was operating and affecting people who were returning citizens. And we did that report with the benefit of data provided to us by the DPP, as well as interviews with DPP staff and affected people on parole. And to summarize what we found, was that the legislature knew that most people on parole would not be able to afford the fee when it created the fee in 1991, and therefore built in these exemptions. And most people on parole are in fact unemployed and unable to afford the fee, yet the system for granting exemptions was broken. Although all these people should be qualifying for exemptions, they're not getting them. And of course, that's what we just heard from my colleague here who just testified. We also found that on average, people on parole were ordered to pay a total of $743 in parole supervision fees over the course of their parole terms. That's of course against the backdrop of all these other fees that I believe you've been hearing about today. And that's also when the fee was only $40. It's since we came up with that number, the fees increased. And we found that only 17% of the fees assessed were actually collected by the end of parole, and that 9 out of 10 individuals had outstanding supervision fee debt when they finished parole. And ironically, while it's called the parole supervision fee, as I think people are aware, the money actually doesn't go to the DPP, it goes to the General Revenue Fund. So at that time, when I wrote this report in 2009, we recommended that the legislature abolish the fee outright. And I think there was some interest in doing that, but what ended up happening was instead of abolishing the fee, there was an amendment to section 7702 of the Correctional Services Law. And what happened was there was supposed to be an improvement in the exemption system. Folks were supposed to get a written notice and an oral notification about the opportunity to apply for an exemption. But I think as we just heard, the exemption system's still broken and it's not really working. And I don't have confidence that if it's not working after this last fix, it doesn't seem like it's ever going to work. And so I would just say that it's time to revisit our initial recommendation, which was to abolish the fee, especially in light of all the harms it causes and the limited revenue that it actually raises. Thank you.
Thank you. Thank you very much. I have a couple questions and then I'll open it up to I see Delegate Taylor for after me. First, a basic question, and I want to direct it to Minister Anderson. You mentioned Turnaround Tuesday. I'd like the committee to know what Turnaround Tuesday is so they can put that in context.
A Turnaround Tuesday is a workforce development movement. Now we say movement because we're not just a program. They work in the community on providing living wage jobs, employment for those who are returning back from incarceration and for those who are in just need of employment and training. We work in conjunction with Johns Hopkins University, University of Maryland to provide living wage employment and other employment institutions across this state.
Thank you for that. Going to Mr. Martin to touch on, I'll ask the question. When you had your trial and you had your attorney, did you have an attorney? I should ask first.
Yes,
Okay. Was your attorney a private attorney or a public defender?
a public fund.
Okay. Wanted to ask that basic question. Delegate Taylor.
Yeah, thank you. And thank you for coming today.
Thank you.
Just for clarification, did you say, or did I hear that the accumulation of parole fees could lead to a potential jailable offense? Is that potentially a jailable offense if you don't pay your parole fees?
Yes, ma'am.
Okay. And then the second question is, could non-payment of these fees also disqualify expungement, if this was an expungible offense, if you didn't pay your fee, could that disqualify this, you from being able to apply for expungement for the offense?
I believe it would, especially if it was a violation that was imposed because of it.
Is there anybody else that can answer that?
The answer is, I believe that's accurate.
Okay,
Yes.
thank you.
All right. All right. Are there further questions? Delegate Phillips is looking like he wants to ask a question, but he hasn't pressed his button yet. And there we are. Delegate Phillips for a question.
Thank you, Mr. Chair. And I think this is for Ms. Dillard. She said something that struck me. Currently the revenue that we receive from these fees, what we charge versus what we receive is significantly different. And can you tell us what kind of revenue we get today from parole fees? Do you have any idea? Did we lose her?
Hi, I don't know the current figure. I can tell you what it was when we did this big analysis. It was 334,000 in fiscal 2008. I doubt it's much different than that, but I don't have a current precise number for you today.
Thank you.
That was a question I was going to ask too, and we'll get that information for the committee. Further questions for this panel? Thank you both very much for taking the time to be with us today, and thank you very much for speaking to the committee and taking the time to come down today. So thank you both very, very much. All right, that concludes the hearing on mandatory fines and fees. So we are going to stop. We are going to have, should we just say 2:30 and leave it at that? All right, so we're going to start the next briefing